Losing a loved one is undeniably one of life's most difficult experiences. In the midst of navigating profound grief, families are often faced with a complex and overwhelming legal process known as probate.
When you should be taking the time to heal and remember, dealing with courts, assets, and legal terms can feel like an impossible mountain to climb. We are here to help demystify this journey for you and your family.
Before we begin, please note that this video is for informational purposes only and is not legal advice. Please consult with a qualified attorney for personalized guidance regarding your specific situation.
When a loved one passes away, you might hear the word probate, but what does it actually mean? Simply put, probate is the legal process of administering a deceased person's estate. It is a court-supervised procedure that ensures everything left behind is handled according to the law. Probate exists for 4 core reasons. First, it validates the deceased person's last will and testament, ensuring it is authentic. Second, it serves to properly identify and calculate the value of all the assets they owned, from real estate to bank accounts and personal valuables. Third, the probate process makes sure that outstanding debts and taxes are paid before anyone inherits. Finally, once these obligations are settled, the court oversees the legal distribution of the remaining assets to the rightful beneficiaries. A judge's final approval brings the process to a close. You might have come across the phone number 330-762-7110 during your initial research. Given the 330 area code, this number connects to a probate court in northeastern Ohio, likely in the Akron or Summit County area. But how do you find the right probate court for your specific situation? The first step is determining the exact county where your loved one resided. Once you know the county, a simple online search like Probate Court Summit County, Ohio, will usually point you directly to their official homepage. There are several other reliable ways to locate the correct court. You can utilize directories on websites like probateus.com, explore your local county government web portal, or simply call the court directly to confirm their jurisdiction and get immediate answers from the clerk. When you finally connect with the right probate court, their office becomes an invaluable resource for grieving families. The clerks can provide essential information regarding specific filing procedures, supply you with the necessary legal forms, outline all required court fees, explain local court rules, and eventually help you track the status of your case over time. The probate process typically follows 7 distinct steps. Step 1 is filing the petition. A family member or lawyer submits the deceased's will, a death certificate, and a formal petition to the probate court to officially open the case. In Step 2, the court appoints a personal representative. The judge signs a document granting the executor, often named in the will, the legal authority to manage the estate's affairs and act on behalf of the deceased. Step 3 is notice to heirs and creditors. The executor formally alerts all named beneficiaries and known creditors. They also publish a legal notice in a local newspaper, giving any unknown creditors a specific window to file claims. Step 4 involves the inventory and appraisal of assets. The executor catalogs everything owned by the deceased, from bank accounts to real estate. Professional appraisers may be hired to determine the fair market value of items like art or jewelry. In Step 5, the payment of debts and taxes takes place. Before anyone inherits, the executor must use estate funds to pay off legitimate creditor claims, outstanding bills, and file final personal and estate tax returns. Step 6 is the distribution of assets. Once all financial obligations are cleared, the executor transfers the remaining assets to the rightful heirs and beneficiaries, strictly following the instructions laid out in the will or state intestacy laws. Finally, Step 7 is closing the estate. The executor submits a comprehensive final accounting to the court. Once the judge reviews and approves these records, the estate is officially closed, ending the representative's duties and the legal process. To understand probate, you must know the key players. It begins with the decedent, the person who has passed away. Stepping into their shoes is the personal representative, who takes on the responsibility of managing the estate. Next are the heirs and beneficiaries, who will ultimately receive the assets.
But first, creditors must be addressed to ensure outstanding debts are properly settled. Overseeing this entire process is the probate judge, supported by court staff who manage the essential legal filings.
Finally, an experienced probate attorney provides invaluable guidance, helping the personal representative navigate legal complexities and protecting the family's interests. Navigating probate is rarely seamless, and families often encounter unexpected hurdles. It can feel like trying to untangle a knotted string or solving a puzzle with missing pieces.
A major challenge is a will contest, where the document's validity is questioned. If this happens, consulting a probate attorney is crucial. You might also face sudden creditor claims, requiring careful legal review before any debts are paid.
Emotions run high after a loss, frequently sparking family disputes over the estate. Instead of fighting in court, professional mediation is an effective solution to help everyone reach a calm agreement. Lastly, you may face missing assets or complex properties like business interests. Conducting a thorough search of personal files and hiring professional appraisers ensures everything is properly valued and accounted for. Probate timelines are unpredictable. Depending on the complexity of the estate and local court schedules, the process can take anywhere from a few short months to several years. Costs are equally variable. You will generally encounter court filing fees and personal representative fees. Representative fees are often calculated as a specific percentage of the total estate value. Additionally, prepare for specialized costs like attorney fees, property appraisal fees, and accounting services for tax preparation. Because every estate is unique, always consult an experienced local attorney to get an accurate estimate of both time and money. While probate is common, there are several methods your family might use to avoid it altogether. Options include setting up a living trust or establishing joint ownership with right of survivorship for your property. You can also add payable on death or transfer on death designations to your bank accounts, or see if you qualify for simplified small estate procedures. As laws vary, always consult a qualified estate planning attorney. How do you find a will? Check their safe deposit box, home office files, or call their attorney. How long do you have to file a probate case? Deadlines vary strictly by state laws, so check your local rules immediately. What if debts exceed the estate's money? The estate is insolvent. Assets pay debts in a strict legal priority order. Navigating the probate process is overwhelming, especially when grieving the loss of a loved one. But you do not have to do it alone. An experienced probate attorney can provide clarity and lift a heavy burden off your shoulders. For guidance and local resources in the 330-762-7110 district, visit probateus.com today. Thank you for watching. We hope this guide helped clarify the probate process, the 330-267-110 district courts, potential challenges, and helpful alternatives. If you found this helpful, please give it a thumbs up. Subscribe for more informative content and share your questions in the comments. We truly appreciate your support.